Welcome. In the next few minutes, you'll learn what to expect if you appeal to the Canadian International Trade Tribunal. The Tribunal hears appeals of various decisions made by the Canada Border Services Agency or the Canada Revenue Agency. The appeals process is designed to be as informal and expeditious as the circumstances and fairness permit. There are 5 basic steps. The process is initiated when you file an appeal within the time frame set out in the relevant legislation. The second step is to file a brief within 60 days. 60 days later, the Canada Border Services Agency or Canada Revenue Agency files its brief setting out its position. Around day 165, the Tribunal hears the matter, either orally or on the basis of the written submissions only. Finally, the Tribunal decides to either grant the appeal or dismiss it. Unless the parties request postponements, the whole process typically takes around 250 days. You can appeal by writing to the Tribunal or using the appeal form. If you have a representative, such as a lawyer, then they need to file a notice of representation too. You can file your appeal and a copy of the CBSA or CRA decision using the Tribunal's secure e-filing system. The appellant's brief should concisely explain why you believe the Tribunal should grant your appeal. Refer to the law and the documentary evidence that supports your case. If you are relying upon legal precedents, please see the Tribunal's practice notice on citing authorities. The Canada Border Services Agency or the Canada Revenue Agency will respond to your brief by stating its position and supporting evidence. It is possible that negotiations on a settlement of your dispute take place, sometimes with steps in the process being postponed if the parties need more time. After the exchange of briefs, the appeal is heard by the Tribunal. Appeals involving the Canada Border Services Agency are usually heard by one member of the Tribunal. Canada Revenue Agency decisions are heard by panels of 3 members. The Tribunal may have an oral hearing before deciding the appeal, or it may proceed without an oral hearing. Oral hearings normally take place at the Tribunal's hearing room in Ottawa, though parties outside the National Capital Region may participate by phone or video conference instead. Oral hearings usually last half a day or a day. If the parties do not dispute the facts and there's no need for witnesses, then they can jointly file an agreed statement of facts and forego an oral hearing. The Tribunal aims to render a decision within 120 days of hearing the appeal. Typically, it issues its decision earlier. The Tribunal provides a statement of reasons for its decisions. Historically, the Tribunal has granted 1 in 3 appeals. If your appeal is dismissed, you may have recourse to the Federal Court of Appeal or, in excise tax cases, the Federal Court. For more information, please consult the Information for Appellants Guide and the FAQs on the Tribunal's website, or contact the Registrar.